Dude, usually when we talk about, like, trying to figure out a problem or a process, there's some kind of, I don't know, expectation that things make sense.
Right. Like a baseline of reality.
Exactly. Like, if you think you broke your arm, you go to the hospital, they take an x-ray, and you literally look at the bone on the screen.
Yeah, it's either snapped or it's not.
Right. It's binary, it's a jagged white line, the doctor points at it, and you're like, cool, my arm is fucked.
Haha. Yeah, you don't have to debate the existence of the bone. You just put a cast on it.
Exactly. It's comforting, because it's real. But man, today we are looking at the legal system, specifically the justice system in British Columbia. And I swear to God, looking at this paperwork, I feel like I'm hallucinating.
It's completely wild. It's like looking at an x-ray, but the bones are floating outside the body.
Yes, the reality of how the law is actually written down versus how these guys are doing it on the street, it's a complete mind fuck. The disconnect is just, it's staggering.
It really is. It requires you to completely abandon any sense of chronological time or logic.
Literally. So, look, if you are listening to this right now, thank you for joining us on this deep dive. I know we're a little unfiltered today, but we need to talk about this.
We have a massive stack of papers in front of us.
A completely ridiculous stack. Official practice directions, the Crown Council Act, the Police Act, pages from this criminal law notebook thing.
And those citizen call logs, the transcripts.
Oh, man, the transcripts are the best part. But yeah, our mission today is to just try and read this shit and figure out how the machine actually works.
Because on paper, our topic today is Section 810, peace bonds, which sounds boring as hell.
It sounds like, I don't know, a parking ticket for being an asshole, a tool for preventative justice, keep the peace, whatever.
Right, sounds totally reasonable.
But then you read these sources and you realize there is this massive, baffling contradiction. We're looking at a situation where a cop can literally hand you a piece of carbon paper at the bottom of your driveway, and suddenly you are banned from your own fucking house.
Over 2 months before they even officially accuse you of anything.
Yeah. Before the legal document even exists, it's a literal paradox.
The paperwork just straight up ignores the actual law. It's crazy.
And look, before we get into it, I want to say we aren't trying to be overly political here. We're not saying, like, abolish the police or whatever.
No, not at all.
We are literally just reading the documents. We're putting the papers side by side and asking, what the hell is this shit? Because when the actual legal procedure doesn't match the written law, you have to ask questions.
Even if the questions sound stupid.
Right.
Because the situation is stupid.
Right. Okay, let's unpack this. We have to start with the blueprint, right?
Yeah.
The basics of a Section 810 peace bond. Pour me a little more of that, would you?
Yeah, hold on. There you go. So looking at Peter Dostal's criminal law notebook, this is the baseline.
The textbook.
Right. A peace bond is fundamentally a recognizance, which is just a fancy legal word for a pledge. You are pledging to the court that you will be a good boy.
Just promising not to fuck up.
Basically. It can be started by the Crown, the defense, or the judge. But the most important thing here, and this is why the rest of this is so screwed up, is that a peace bond is not a criminal conviction.
Right. I need to hammer this home for anyone listening. If you get a peace bond, you have not been found guilty of a crime. You are legally innocent.
Completely innocent of whatever crime they investigated.
But even though you aren't convicted, this peace bond completely restricts your freedom. They can tell you where you can't go, who you can't talk to, what you can't do.
Welcome to preventative justice, man. It's the Minority Report shit.
Dude, it really is. Tom Cruise in the bathtub.
Exactly. So there are 2 parallel tracks for this. You have criminal code peace bonds, which are under sections 810, 810.1, stuff like that.
And then the common law ones, right?
Yeah, common law peace bonds. Those come from like ancient historical judge rulings, not a specific modern statute.
Okay, so why does the difference matter? Why do we care?
Because of the hoops they have to jump through to get one. To get a criminal code peace bond, the law says you absolutely must swear an information.
Swear an information. That means someone has to go in front of a justice of the peace, raise their right hand, and swear under oath that this person is a risk.
Yes, you can't just skip that. But a common law peace bond doesn't necessarily require that formal sworn information.
Which is convenient.
Very. And the timelines are different too. Criminal code bond usually maxes out at 12 months. A common law bond, theoretically, it could last forever. No maximum duration.
That's terrifying. Just endless good behavior pledges.
And the reason you get one is different. The criminal code needs reasonable grounds that you will do something dangerous or illegal. The common law just needs a reasonable apprehension of a general breach of the peace,
Which sounds incredibly vague, like you might yell at a guy at the gas station.
pretty much. But here's the kicker for both of them: the standard of proof.
Oh, right. The burden of proof. It's not beyond a reasonable doubt, right? Because it's not a criminal trial.
Yes, exactly.
You strip away your liberty, they only need a balance of probabilities.
Which means 51%.
Yep. 51% likely that you might do something bad in the future.
I mean, that is wild. They aren't punishing you for something you actually did. They're looking at you and saying, it's slightly more likely than not that you're going to be a problem, so we're restricting your rights.
It's totally preemptive. The goal is stopping conduct before it happens.
But, wait, if it's not a conviction, how much teeth does this actually have? Are we just, asking people nicely to behave?
Yeah.
Because if I promise not to go to a bar, and then I go to a bar, what happens?
Oh, dude, the teeth are practically fangs. This is where it gets super serious. Section 811 of the Criminal Code covers the breach of a peace bond.
Okay, what does Section 811 do?
If you breach a condition, it's an absolute jurisdiction offense. You don't get to choose how you're tried. You are going straight to a provincial court judge.
Oh, shit.
And the penalties are insane now because of Bill C-26.
The Tougher Penalties for Child Predators Act from 2015, right? I was reading that. Yeah. The name is totally politically loaded to make sure nobody votes against it. But it didn't just apply to child predators. It jacked up the penalties for every single Section 811 breach.
Holy shit. So if you just text someone you aren't supposed to text under a peace bond.
Yep. For a summary conviction, the maximum jail time tripled from 6 months to 18 months.
A year and a half for sending a text message.
And if the Crown decides to go hard and proceed by indictment, the maximum penalty went from 2 years to 4 years.
Wait. 4 years in federal prison?
Yes, 4 years.
Let me just wrap my mildly intoxicated brain around this.
Yeah.
You can get 4 years in a federal penitentiary for breaking a rule from a peace bond that was given to you based on a 51% guess about what you might do for a crime you were never actually convicted of.
That is the exact reality of the law.
That is fucking wild. That is so much power.
Right. And because it's so much power, the law is supposedly full of safeguards. That's why they demand the sworn information. They demand the Crown prosecutor looks at the file. They demand a judge actually weighs your freedom against public safety.
The theoretical blueprint. It sounds so nice and safe. You have all these smart lawyers and judges protecting your rights.
Yeah, that's the theory. But then you look at how it actually operates in the real world.
Right. The bureaucratic machine. Because, let's be real, the courts are backed up for years. Judges do not have the time to sit there for 3 hours debating a 51% probability for every single idiot who gets in a bar fight.
They absolutely do not. The system would collapse tomorrow. So to understand how they survive, we have to look at the Crown Counsel Act and this other document, CPD-1.
The practice direction from the chief judge of the provincial court.
What's fascinating here is how much they rely on administrative delegation to just keep the line moving.
Yeah, it's like a fast food drive-thru. Okay, so under the Crown Counsel Act, BC has this pre-charge screening model.
Right, meaning the cops can't just slap a formal criminal charge on you themselves. They investigate, but then they have to submit an RTCC.
A report to Crown Counsel. They gather the evidence, put it in a folder, and hand it to the lawyers.
The Crown Counsel has the exclusive power to approve prosecutions. Section 4 of the Act says the Crown has to examine all the info and approve it if they think it's appropriate.
So the Crown is the filter. They're the bouncer at the club, making sure the cops aren't just bringing in garbage cases.
Exactly. And only after the Crown says, yes, this is a valid case, does someone swear the information in front of a justice of the peace to officially start the court process.
Okay, so a nice, clean, linear timeline. Police investigate, Crown approves, information gets sworn, court takes over.
Beautiful, right? But then you read CPD-1.
Oh, man.
Yeah.
CPD-1 is just, it's like an instruction manual on how to avoid doing actual court stuff.
The whole point of that practice direction is to stop people from ever walking into a physical courtroom. They've delegated almost everything to JCMs.
Judicial case managers, which, by the way, are not judges.
Not even close. They are administrative staff, schedulers. Their entire job is just processing the meat through the grinder as fast as possible.
Yeah, paragraph 9 says all out-of-custody non-trial appearances go to a JCM. So if you're not in jail and you don't have a trial that day, you don't see a judge, you see a scheduler.
And to make it even faster, they have these consent forms, Form 1, Form 3, Form 4.
The consent remand Form 3 This one blew my mind, paragraph 32.
Yeah, read what that does.
If your lawyer submits a Form 3, you are literally waiving your constitutional right to appear in court. You are saying, yeah, go ahead and process my legal fate while I'm not there, and you agree to stay under the court's jurisdiction without ever making eye contact with a magistrate.
It's perfectly optimized. It's an oiled machine. They just fax these forms in, the JCM stamps it, and boom, next file. The document actually says it's for the benefit and convenience of counsel.
Convenience, that's the metric, not justice, not oversight. Just, is it convenient for the lawyers?
Yep. The fiscal courtroom is gone. It's just a digital paper trail managed by clerks.
Okay, so on paper, for the lawyers, it's super slick. But what happens when a regular dude, a citizen, gets caught up in this and tries to read the instruction manual?
The whole illusion just shatters. Which brings us to New Recording 95.
Haha, yes. I love this transcript.
It's incredible. It's a recording of a citizen calling the Duncan Court Registry.
So this guy is logged into the Court Services Online System, the CSO, looking at a screen, looking at a specific case file, and he's just trying to figure out how this Section 810 peace bond actually started.
Right. And he asks the clerk a super basic question. Does this start with an application?
And the clerk immediately assumes he's a victim, like, oh, did you report it to the cops? And he's like, no, I'm just reading the public record and trying to understand the steps.
The clerk tries to give him the dummy version. You just go to the police, and we deal with the applications here.
But the caller isn't an idiot. He's been reading the actual laws. He's like, wait a minute, the law says you need a sworn application, a judge reviews it, and then you get a summons. The cops can't just do it themselves.
And the clerk gets super defensive. She calls his research mimble-jumbled.
Mimble-jumbled, that's a direct quote. You're reading mimble-jumbled stuff online. But then the clerk literally recites the correct law back to him.
I know. She says, the cops gather it, give it to Crown, Crown reviews it, and then they swear in information to get it in front of a judge.
She literally confirms the linear process we just talked about. Cops, Crown, sworn information, judge.
But the caller is looking at the live database for a specific file, and he sees something totally fucked up.
Right, because the computer screen shows that a cop issued an undertaking a legally binding restriction way before the information was ever sworn.
The caller literally says, hold on, how could there be an undertaking from the officer if it begins with an application or in front of the judge?
Okay, my brain is starting to hurt. Let me use an analogy here because this makes no fucking sense.
Go for it.
It's like, imagine you're driving down the highway in May. A cop pulls you over for speeding. He hands you a ticket and says, give me your license. You're suspended right now. He takes your license on the side of the road.
Okay.
But the cop doesn't actually file the paperwork or log the radar gun or swear under oath that you were speeding until August.
Right. 3 months later.
Yeah. So your punishment, losing your license, happened in May, but the legal accusation didn't even exist until August. How does the punishment precede the accusation?
It doesn't. Logically, chronologically, legally, it is impossible.
So what does the clerk say when the caller points this out?
This is the best part. She says, and I quote, you would have to ask the RCMP how they have the power to do that. Because I don't know. I just know that the RCMP have the power to do that. It's granted in our legislation.
I don't know, but they can? That is insane. That is the sound of the entire system just shrugging its shoulders.
She assumes there must be some secret magic law that lets the cops do it, because otherwise the paperwork she's staring at is illegal. And her brain can't process that.
Because we read the legislation, the Crown Counsel Act, the Criminal Code. There is no law that says a cop can bypass the justice of the peace and just slap a peace bond on you at the side of the road.
Exactly. But the bureaucracy just trusts the paperwork. The paper exists, therefore the paper is God.
So we have to look at the actual case file this guy was talking about, file number 45248, the roadside justice document.
Yeah. This is where it goes from funny bureaucratic confusion to actually deeply fucked up.
Let's walk through this timeline. Tell me if I get this wrong. June 2, 2023, this guy gets arrested at his house for uttering threats, section 264.1.
Standard criminal arrest. But he's never taken to the police station.
Never taken to the station, never put in a cell, never sees a judge for a bail hearing, nothing.
The cop just pulls out a Form 10 undertaking right there in his driveway.
Okay, and a Form 10 is supposed to be used after a lawful arrest to release you and give you a court date, right?
Right. But look at what the cop wrote on it. He wrote section 264.1, the threats charge.
Yeah.
He wrote section 810, the peace bond.
On his own. Without the Crown. Without a judge.
A cop just unilaterally initiating a preventative peace bond on a piece of carbon paper.
And the conditions on this Form 10 are brutal. The cop instantly imposes a residential exclusion. He literally kicked this guy out of his own home. On June 2nd, you can't live here anymore. Sign this paper.
Plus mandatory fingerprinting dates and a court date.
Okay, so on June 2nd, this guy is legally banished from his house. Now let's look at the next date in the file.
August 3, 2023.
61 days later.
Yep. On August 3rd, Justice of the Peace Clemens finally swears the official Section 810 information.
Are we stupid, or is this just completely broken? The legal foundation, the sworn information that the law requires to start a peace bond was signed in August.
Yes.
But the cop used that peace bond to kick a guy out of his house in June.
This raises an important question, doesn't it?
How the fuck does that happen?
How does an undertaking restrict your liberty for an offense that literally won't exist in the legal system for another 2 months?
It's time travel. The system is prosecuting people with time travel.
The registry clerk said it herself, Crown approves, JP swears it, and then conditions are validated. But the court's own database proves the exact opposite happened here.
Nothing official, just in paper. A cop wrote it down, and suddenly the guy is homeless.
And it gets worse. Let's fast forward a year, September 24, 2024.
Oh, right, because the guy missed the court dates from the first bogus Form 10.
Exactly. So now there's a warrant out for him. The cops interact with him again on the side of the road.
And they hit him with a second Form 10. Sign this or I'll arrest you on the warrant.
But look at the charges on the second Form 10.
It only says Section 810. The original criminal charge, the uttering threats, is just gone.
Erased. Because the Crown probably looked at the RTCC months later and said, this threats charge is garbage, we have no evidence.
So they threw out the real crime. But the peace bond, the 51% probability pledge, stayed in the system like a fucking zombie.
The ghost in the machine.
Hmm.
It survived the filter and got sworn in August.
This is making me so pissed off. Okay, so the second Form 10 gives him a new court date for October 8, 2024.
He doesn't show up.
Obviously. And so what happens on October 8th?
A formal warrant is issued for his arrest.
By a judge, someone who actually looked at this absolute clusterfuck of a timeline and decided this guy needs to go to jail.
Nope. The public record says the warrant was issued by Mrs. Campbell on behalf of the judicial case manager, Mrs. Cole.
A scheduler. An administrative assistant printed a warrant for a man's arrest because he didn't show up for a court date that was generated by a chronologically impossible piece of police paperwork.
For an offense that didn't exist when he was originally punished for it.
This is actually fucked. Like, we're laughing, but this guy's life is being ruined by Microsoft Excel.
The algorithm doesn't care about timelines. The cop inputs the Form 10, the computer says he has conditions, he misses the date, the computer says print warrant.
There was zero judicial process here. He never saw a station, never saw a lawyer, never saw a judge, just a cop with a pen and a clerk with a stamp.
A closed loop of bureaucracy.
Okay, but hold on. If this is happening, who watches the watchers? If a cop is just making up peace bonds on the side of the road and the computer is blindly enforcing them, who is supposed to catch this?
We have to look at the Police Act for BC. Accountability structures.
Right, because there has to be some oversight.
There are two main bodies, the Independent Investigations Office, the IIO, and the Police Complaint Commissioner.
Okay, let's start with the IIO. What do they do?
Under Part 7.1 of the Police Act, the IIO investigates cops, but only when an officer causes death or serious harm.
Okay, so if a cop shoots a guy or beats him into a coma, the IIO shows up.
Exactly. It's for extreme physical outcomes.
But in our case, the guy wasn't physically hurt. He was just illegally banished from his house for 2 months by a piece of paper.
Right. There's no blood, no broken bones, so the IIO has zero jurisdiction. They don't care about administrative paradoxes.
Fine. So what about the other guys? The Police Complaint Commissioner.
Part 11 of the Police Act. The commissioner handles public trust offenses and abuse of authority.
Okay. That sounds like what this is. An abuse of authority?
You'd think so. But practically, that language is used for overt corruption. Like if a cop takes a bribe from a drug dealer or plants a bag of coke in your car.
Or like intentionally lies on a stand.
Yeah. But how do you classify a cop filling out a Form 10 with a charge that isn't sworn yet?
It's not a bribe. It's not a physical assault.
The system just classifies it as a clerical error, a routine procedural anomaly.
A glitch. Oops, the cop filled out the wrong box on the carbon copy, so nobody investigates it.
Exactly. If a cop pockets $50, he gets fired. If a cop uses a clerical error to illegally evict a citizen for 61 days, it's just a scheduling oopsie.
So what does this all mean? Like, seriously, where does this leave us?
It means the justice system is relying entirely on self-fulfilling institutional trust.
Okay, break that down for me. I'm a little slow right now.
Everyone in the chain just assumes the guy before him did it legally. The court registry gets the Form 10 from the cop. The clerk assumes the cop has the legal authority to issue it, just like that lady on the phone. I don't know how, but they can.
So they type it into the database.
Then the Crown prosecutor gets the file months later. They look at the database, see the guy was arrested and released on conditions, and they assume the initial arrest was totally legal.
So they swear the information in August, thinking they are just finalizing a legal process that started in June.
And finally, the cops rely on the court to legitimize their roadside bullshit. When the guy misses court, the judicial case manager, the scheduler, just looks at the computer, sees a missed date, and prints the warrant.
Oh my God. Nobody actually reads the whole file from start to finish.
Nobody has the time. Remember CPD 1. The whole goal is throughput. Keep the line moving.
So you have this noble idea of preventative justice. Section 810. Protecting the public, balancing liberty, a judge carefully weighing the odds.
The blueprint.
Yeah, the blueprint. But in reality, it's just a Kafkaesque nightmare of paperwork. A cop hands you a paper, the computer eats the paper, and the computer spits out a warrant.
And if you complain to the registry, they tell you to ask the police.
And if you ask the police, they tell you to talk to the judge.
But you can't see the judge because the JCM intercepts you and says, you missed your date, here's your warrant.
And the oversight bodies say, nobody got shot, go away. You are completely trapped in a loop.
You're fighting a ghost in the machine.
I actually feel a little sick. Like, we started out making fun of that clerk in Duncan, but this is terrifying.
The system is blindly digesting unlawful paperwork.
Which brings us to, like, the ultimate question, the final thing I want everyone listening to think about.
Yeah, lay it out.
If this one case file, 45248, slipped through so easily, if the court services online database just happily accepted a punishment that happened 61 days before the legal accusation,
Right.
how many other files are in that database right now? How many other clean digital records are actually just phantom legal processes?
How many other arrest warrants are active right now because of a piece of roadside paper that was never actually vetted by a judge?
Are these computers just automated rubber stamps for the cops to do whatever the hell they want without ever going to court?
It's a terrifying thought. And the oversight mechanisms literally aren't built to find out.
Man, we need another drink.
I'm way ahead of you.
Well, look, if you stuck with us through all of this swearing and confusion, thank you. This deep dive was a heavy one.
But a necessary one.
Yeah. Look closely at the systems around you, man. Just because it's printed on official paper doesn't mean it's the truth. Sometimes the paper is the trap.
Stay safe out there.
We'll catch you next time. Peace.